Good afternoon, everyone, and happy Friday. And welcome to today's session. In today's session, we're going to discuss about the continuing family law topic, which is financial remedy. As you are aware, we have first discussed divorce and then child arrangement, and in today's session, we'll be discussing the financial arrangement. And we have got the family expert, solicitor and barrister, as well as director of Avista Solicitors, Mr. Khondoka Omar Farooq. Mr. Farooq, welcome to the today's session.
Many thanks, Jadeb.
So, as you were aware that we are doing like family law sessions. So, if I just start with in today's session, if I just start with the basic thing, that what does financial relief actually mean?
Financial relief means the financial arrangement
Mm-hmm,
between the separating couple who has divorced or uh, dissolved their civil partnership, and it includes after the divorce or dissolution of civil partnership, their property asset, um, savings, pensions, shares, whatever, child
mm-hmm.
maintenance, property, and children's maintenance. So it's only after the divorce or dissolution of marriage, civil
Okay.
partnership.
So, does it always means that if a financial remedy is provided, that the parties will get like 50-50?
Not, absolutely not. The
Mm-hmm,
first thing is once a divorce or dissolution of civil partnership occurs, it doesn't mean that the financial arrangement or financial remedy has also been finished. It remains open for years to come unless there is a settlement.
mm-hmm,
This is a common myth that is 50-50. It's not that straightforward. It's quite complicated because it involves a lot of things like the parties' um, housing needs, parties'
mm-hmm,
age, income, capacity, future income, um, the what was the lifestyle before the marriage, and if there are children, what would be their maintenance. So it's not always straightforward. Duration of the marriage is a big factor because if the marriage lasted only few months, few years, whereas if the marriage lasted long time, 10, 15, 20 years, there are children, and also other important factor is contribution to the family assets or finances by each party as well.
mm-hmm,
But important thing, like it has to be fair, not equal. It has to be fair. If, say, for example, one party has several assets and other party has got no asset, and if I can say that the party has had a um, prenuptial agreement that um, once the party is divorced or separated, they will have their rights and liabilities determined by the prenuptial agreement.
mm-hmm,
Even the court can overlook that because the settlement agreement or financial settlement has to be fair and reasonable. While you are living in
mm-hmm,
a palace, the other side cannot be left on the street. It doesn't matter. I mean, we see a lot of times like one party produced a prenuptial antenuptial agreement which says, okay, in case of divorce or dissolution of civil partnership, the other party will receive £50 a week. Come on, this is UK. you can't you can't meet your ends need with £50. So
Okay.
normally, generally, I mean, it's not mandatory in the UK, but increasingly the court is giving effect to the antenatal agreement, provided it's fair and reasonable. So it's not always straightforward. It's 50-50.
All right. So you have nicely pointed out that the court will consider what is fair and equitable as well as reasonable. not equality.
Absolutely.
So, yeah. So, the thing is, I mean, this is a very important and hot topic, family home, especially when there is a children. So, I know that you have mentioned lots of factors that the court considers, but when it comes to the family home, is there any specific thought that comes to the court's mind as well?
Well, regarding financial settlement or remedy, Section 25 of the Matrimonial Cause Act 1973 will come into play, where you have to follow certain criteria. But if normally, if there is a family home and there are children involved, um, if the parties cannot reach an agreement and later approved by the court that the family home will be written by the parent who is the main carer of the children, then obviously
Hmm.
it will go to the court, and the court probably will, in that case, they will look for the best interest of the children, you know. Then it
Hmm.
then other factor will be less important that time, because again, if you have one family home and two children or one children and main caring parent, they cannot be on the street. I mean, provided their housing in other, if they move out, their housing needs are met. And if they have to rent or they have to uh, pay a mortgage, that also have have to be met by the other parent.
All
Again,
right.
regarding both parties' income as well, and
Okay.
assets and.
Yeah, I get it. So the thing is, I believe you have touched it. So I just want to be clear with the viewers that, yeah, when we are talking about maintenance to the other party, I mean the spouse, what are you looking at, short-term or long-term maintenance?
Well, if one party is in financial need, she can apply for financial maintenance. Generally, it's for short term. But if it is long term, it won't be surprising. But generally,
Yeah.
financial maintenance for a short time for the party who has financial needs.
Hmm. Okay. So another thing I want to be specifically, I mean, clarified is the pension. You know how important it is in the UK system. So how it is affected in financial remedy cases.
Well, that will also be taken into account if the parties cannot reach an agreement. The way it would work, you reach an agreement with the help of the mediator, arbitrator, or with your solicitor, and then you produce it before the court for approval. The court will not just stamp it. They will
Hmm.
want to see you have to provide free and frank and honest disclosure of your both parties' financial asset. And again, they will see whether it's a fair settlement. Then obviously the court will approve. So um, the pension one, if you can't agree, the court will impose that, okay, excess percentage of your pension from excess pension provider will go to your other party. It can
Okay.
be. This is how it works if the parties cannot agree. You know.
Okay. So
Again,
yeah, sorry.
yeah. Again, it has to be fair. Like one party
Yes.
was married for like 1 year or 2 years. She has
Hmm.
contributed zero, no children. And then she said, okay, the other party has got a hefty pension. And
Hmm.
the party in need, obviously they can apply, but what will be the percentage and how much they'll get, it will be quite challenging.
All right. Yeah, I got it. So the thing is, you have said that if there is a consent order, sorry, if there is a mutual agreement, then that's fine. If there is no mutual agreement, then they need to go to the court to get an order. So my question comes to that mutual order. For example, if there is a mutual order, and you're saying that it's a good idea to get a consent order on that from the court. Why is that?
Because if it is not approved by the court, it may not be binding.
Mm-hmm.
Um, we always advise client get a consent order approved by the court. We sometimes see client they have an agreement reached between the parties after a divorce,
Mm-hmm.
but that's not binding. They said, "Oh, we get it done by a solicitor and with the help of a solicitor," but it's not binding. To make it binding, it has to be approved by the court. You know, and we also encourage. This is also the family code rules as well, and family code guidance that you always encourage parties to reach an agreement before you go to the court. It's called consented or contested.
Yeah.
So if it is consented, probably it will be less expensive. If it is contested, it will be very expensive because there will be a lot of hearings. You have to instruct family council, and
Mm-hmm.
it will be lengthy as well. And at the end of the day, you will have to pay a lot of legal fees. And in some
Mm-hmm.
cases, it may not be worthy. And as you said, like uh, people think it's 50-50. No, no, it's not. It's not true. It's not true. It's not true.
Yeah. So another thing I want to touch upon that you have mentioned is that full and frank disclosure. We have heard the term in our BTC days in civil. So when you say that full and frank disclosure by the parties, so what does it actually mean and how it can impact a financial order?
Full and frank disclosure. Even if you have a consented order,
Hmm.
um, you have to disclose all your assets, liability, pension share, wherever, both parties.
Hmm.
If you hide asset, which happens sometimes, offshore companies and blah blah blah, in a different name. So what happens? You have an order, and then
Hmm.
later it was found out that you have an honest in disclosing your assets and liabilities. The court can penalize you. The court can reopen that consented order, and you will be penalized heavily.
You mean sanctioned?
Yes.
Okay, great. So I mean, I believe I have a clear idea now, and I believe the viewers will have a clear idea as well. If you have got any question, then definitely you can shoot it to us, and we'll be try our best to answer your questions. So, if I come back to you again, then I mean, you are an experienced family law practitioner. So, what will be the key advice to our viewers when it comes to the financial remedy? And how you can, I mean, Avista can help in this regard.
If there is a divorce, we advise always to get a financial order approved by the court.
Hmm.
And the risk is that, say, for example, you are divorced, or your civil partnership has dissolved, and at the moment you don't think that there is not mass asset, and you don't need any order or anything, but you are always prone to be the risk of losing future earning because the other side can come back anytime. And
Hmm.
they said, okay, I give an example always, like, say, for example, tonight, I think it's euro million drop, and you won 100 million.
Hmm.
Tomorrow, in the newspaper, your ex see that news, and she or he come back and say, hang on that winning jackpot money, I have a bite, right? And I have a bite. But obviously, if you have a clean break agreement, we call it clean break because that's the end of it. No
Hmm.
responsibilities, no liabilities. Um, so as soon as you entered into a binding financial agreement, after that, whatever you earn is yours, whatever you spend is yours, other side as well. So your
Hmm.
earnings, other side will have no say, and vice versa. So we always recommend our client after the divorce get a clean break financial order agreement in place and it is binding.
All
Avista
right.
is always here to listen, and if you need our assistance in reaching an agreement with your ex, we are always happy to assist. Thank you.
All right, great. I believe this discussion has been very helpful for our viewers, and it will be in future as well. And definitely, if the viewers have any question, any type of question, or they're looking for any legal representation or advice, then you can reach out to Avista Solicitors at the given email and the phone number, as you can reach out Mr. Khandokar Omar Farooq to the website. So, thank you, Mr. Farooq, for joining us today and discussing this very important topic. And I also want to thank our viewers for their continuous support in our program. Thank you.
Thank you, everyone. Thank you. Have a good evening and have a lovely, great weekend. Thank you.